Let me say, last week we discussed this issue, but not too into details, and I made one point clear, that this CJ has set a record on the number of petitions received by His Excellency the President. Not there was a petition against her under President Nana Akufo-Addo, and a petition against her under John Dramani Mahama. What is significantly wrong? You understand? And if you consider the fact that the petitioners, especially the one under Nana Akufo-Addo, wasn't just an ordinary member in society, a professor of law, who used to be a member of the MPP. So what really was wrong about the CJ that people do not know? And I also mentioned the fact that it's only been under this CJ that even the National Security Advisor had cause, the National Security Minister had cause to complain about perceived bias of the judiciary. So there may be...
As Albert Kandaba.
Yes, there may be some substance in people's perception about the judiciary under this CJ. Two, persistently, the Integrity Initiative have found our judiciary wanting on their league table. So I think that people should critically look at the attempt to reform our judicial system more than personalizing this issue about the CJ. Because remember Justice Atuguba, you remember the former Justice Atuguba, I'm talking about Justice Atuguba, the Professor Atuguba first, and then Justice Atuguba second. You also had the late Justice Sulik Badegbe himself, and other people have raised questions about the perceived bias of the judiciary, and also critically people thinking that the judiciary has not been fair to them on many issues. So when not one, not two, three petitions came up, the president, as democratic as he is, was constrained. Under the Constitution, he has no option. It was mandatory on the president to consult the Council of State on the petitions received and then determine what process we should go ahead and follow as enshrined in Chapter 11 of the Constitution. You know, so he did what he's supposed to do. And so far, the president has been very consistent in abiding by the Constitution. He submitted the petition to the Council of State to determine whether there is a prima facie case for the CJ. Contrary to some of us our interpretation of the Constitution, because under the Constitution, there is no place that says the president must give the copy of the petition to the person who has been petitioned against. But President John Dramani Mahama, believing in the principle of odi otaram partem, willingly gave a copy to the CJ for him to prepare himself before she faces the committee if a prima facie case is established. Nana Akufo-Addo did not do that. The constitutional lawyer did not do that. But President Mahama...
In which of the instances?
The petition against Charlotte Osei.
Charlotte Osei. Okay, very well.
You understand? There was also a petition against Loretta Lante.
Loretta Lante, yes.
Who was then the head of Shraj. She wasn't given a copy. You understand? But in this particular instance,
John Mahama, that was under John Mahama.
John Mahama, yes.
Yeah.
And in this particular, John Mahama, giving consideration to the high office of the Chief Justice, decided that, look, let me give the lady an opportunity to respond or to know what is being said about her. Even before the Council of State will come to the determination that there's a prima facie case. So that was done. And then now it has become clear that then the president went ahead and exercised the authority under 146(10). You understand? To ask the CJ to step aside.
Yeah.
I've heard people talking about the fact that in that particular instant, in all the articles before, or in all the clauses before, mentioned shall, and this particular instant, they said may.
May.
They said that if once may is used in the Constitution, the person exercising that authority and that discretion should not exercise it with a capricious intent, and also must be just and fair. In this particular instant, President Dramani Mahama has been fair, has not been capricious in any way. He has given the Chief Justice the opportunity to even know the petition against him, what is said against her. And she even has gone ahead to respond to those petitions. Instead of waiting to appear before the committee and responding to them, she has publicly responded to those issues. So she has put the issues in the public domain. Even though the whole committee's work is supposed to be in camera, she has put her response in the public domain. Because you can't tell me that if she had not given her response to a second or third person, we would have had it within the public. You understand?
Has the Council of State seen this response?
I don't think her response was meant for the Council of State. You understand? President Mahama did not give her a copy of the petition for her to respond to the Council of State, because the Council of State have not called her. The Council of State will only determine whether there's a prima facie case against her.
But will her response aid the Council of State in making such determination?
Well, then that lies within herself. If she decided to respond, make a response public, that may have, in one way or the other, affected the decisions of the Council of State. Because if I'm going to tell the issue about you, I don't know what you're going to say, and then you voluntarily gives me an interpretation or an interest in what has been written against you. You give me opportunity to be able to judge you better.
Yeah.
Do you understand? So that is what has been. So the president has dutifully and duly responded to the constitutional provision, and I've asked her to step aside. That is only fair play. That is just. Because she is the Chief Justice. Assuming she is still exercising that authority as the Chief Justice, and 2 justices of the Supreme Court are on this committee, don't you think she could have an overbearing influence on their decision?
There's been argument about the composition of this committee and whether a sitting justice of the Supreme Court should even be represented there.
But that's what our Constitution says. As at now, that's what our Constitution says. That there must be 2 justices from the Supreme Court. One should be the chairman. And that's what the Constitution says. You understand?
Yeah.
And 3 others who should not be members of parliament and also should not be of the judiciary. You understand? So maybe me and Aset could have qualified to be on the committee at this time because we are ex-members of parliament. You understand? But it's been composed. I would have wished that instead of giving the public the opportunity to judge her before she appears before the committee, the CJ would have waited, appear before the committee, and maybe put her convincing arguments before the committee.
Right.
Her fellows are sitting on it.
Right.
In their judgment, they will be, and because they are Supreme Court judges, maybe their thinking and thoughts will influence the decision of the others who are not members of
Exactly.
But now you've given us opportunity, all of us, to judge you within the public space. So even before the committee will come out with its work, I have made a determination already, based on the facts from her own response. I would say that she acted wrongly, and she didn't exercise her discretion well in those her travels on that particular single petition, or which was on her travel. You understand? I've been a minister before. And Nana, let me tell you, sitting here, so many instances where my own spouse has fought me for not taking the opportunity of traveling with her. When I was a minister, I said, how am I going to buy your ticket? If I didn't have the money to buy your ticket, it would be wrong for me to use the ministry's money to buy your ticket.
Very well.
You understand? So even me, the ordinary person, know the limit of my discretion as a minister using the public funds in such situations. How much more the Chief Justice?
Was she entitled to this?
She partly entitled when it's one. You see, there were two basic principles under their travel policy. One, dealing with your private travel, and the other dealing with official travel. According to her, and in her response, when you read it very well, it looks like she was misled by the Judiciary Secretary in misinterpreting that policy direction that says that you could use your private travel as official. You understand? So the benefits under private official travel could be used under private travel. But that is not what the policy says.
Very well.
If the policy say A, it must be A. Especially when it comes to issue about the judge, who will blame me for not using that discretion wisely if I was appearing before her. So I think that where it's gotten to, we must not be quick to condemn or say that our constitution is not working. It's not. Yes, I agree that there are a lot of lacunas and a lot of ambiguities when it comes to interpreting some of these clauses. But to some extent, it has served us well.
Indeed.
In the good intention of John Dramani Mahama, he has put together a committee to look at the review of the constitution. Until that, this is what is working with us.
Very well.
And as of today, when you and I infringe on any clause of the constitution, you will be dealt according to the details of the constitution.